have told you about how to plan your move financially. We have given you some useful information about costs you can save on the actual transactions. What about actually buying a house or doing whatever it is you want to do in Portugal? Specifically, we have got several lawyers, obviously as part of the chamber, but we have asked our corporate member, Gonçalo Figueira, from Edge International Law Firm in Lisbon. Where is he?
I'm here in Portugal.
Oh, there he is. All right. In Lisbon, Portugal, yes. Edge International has offices all over Portugal. But we have asked Gonçalo to come and walk us through the actual legal steps that you will be following if and when you buy a property in Portugal, and what the costs are that are associated with that. Gonçalo, do come and tell us more.
Hey, good morning, everyone. It's very good to be back here in London after these 2 years, and I hope now we can keep on doing these presentations and interact more frequently. In this first presentation, we are going to talk about the legal side of a property purchase in Portugal. And that's very important for a number of reasons, but in particular for someone who is used to the Anglo-Saxon, to the UK model. There are a number of differences when you buy in Portugal. The Portuguese system has a lot in common with the continental Europe system. We have a civil code, which there isn't here. So one of the things you'll notice is that our contracts are not as dense, don't have as many pages as the UK contracts. And the reason is very simple. It's because most of the rules are already in the law, in our civil code. The first thing that I would like to stress is that you should never buy a property in Portugal without legal advice. Why is that? It's a different country, a different jurisdiction, and you don't want to have a bad experience or to risk your investment. In some cases, you may hear that you don't need that, or that the brokers will do that for you, but you should take in mind that you should have an independent in the sense of representing you, and not someone who is in the side or is of the seller, of the broker, or it has an interest that the sale is made. The interest of your legal advisor, of your lawyer, is that everything goes well and that your interests are protected. Okay, so normally we have a three-stage process, and it comprises the due diligence, in most cases, the signature of a promissory contract for purchase and sale. I will immediately after this say why in most cases. And finally, the signature of the final deed or contract of purchase and sale, which is the completion, as we call here in the UK. Due diligence. This is a fundamental stage. And what we normally do is, once you find a property that you would like, that you are interested, we request a number of documents from the brokers or directly from the seller's lawyers, so that we can prepare a report for you. And in this report we cover all of the property documents, without wanting to be too detailed, but in Portugal all the properties have a land registry document, which basically states the details of the property, the current owners, and very important, if it has any charges on the property. every property in Portugal also has a tax document, tax department certificate, which should match in terms of, for example, the square meters and all of that, the land registry document. It also has an important information, which is the property tax value. I will cover that in a few minutes, but just as an introduction, each property in Portugal also has a tax value. And the tax value does not necessarily relate to the market value. And in most cases, it's substantially lower than the market value. And thank God, it's on the tax value that your yearly tax on the property is calculated and not on the market value. Then we have energy certificate, which I believe you also have here in the UK. The utilization, sometimes also called habitation license, which basically is the document issued by each local town hall. The local town halls in Portugal are the planning authority for all habitation. Then for properties built after 2004, there is also a very thorough document detailing all the technical aspects of the property, which is called the technical habitation license. These are the main fundamental property documents for due diligence. When the seller is a company, we also do a basic due diligence on the company, and we require a company certificate as well. So now we go back to the second, we move on to the second stage. And the reason I say that it's in most cases is because the promissory contract of purchase and sale is not mandatory according to the Portuguese law. Having said that, in most transactions, people sign a promissory contract of purchase and sale. Why is that? The fundamental reason is to guarantee both parties in terms of the buyer, or as we call the promissory buyer, will not have the risk that the seller is going to sell to someone else, because it will be under a contract. And the same applies to the promissory seller. That there is a commitment from the buyer that he will buy that. And why is that? Because there will be a deposit payable. There is no, and this is a question that for the last 20 years everyone asks me, how much is the deposit? And I always say that it's up to you and the seller to agree. What does this mean is, there is no legal rule in Portugal for this. It's up to the parties to negotiate. So if someone tells you, oh no, you must pay X%, you mustn't do anything, you must agree on something. But it is true that the market practice, the normal value of a deposit is between 10 and 20%. Having said that, can be 1, can be 99, it's up to the parties. Another important element in the promissory contract is deadlines, timeframes. So, what will be the deadline for completion, for signing of the deed of purchase and sale? And again, the legislation is liberal in terms of allows the parties to agree on that. So it can be anything between immediately the next day or in 2 years' time. But the normal, again, is never less than 1 month. I would say in most cases between 1 to 3 months. When the time comes for the title deed, what you call in Portuguese the escritura, this is the time where after it's signed, it can be in a notarial office or in a solicitor's or lawyer's office, you actually become the legal owner of the property. Because when you sign the promissory contract, you don't become the owner, you just have a contractual right. When you sign the final deed, you have a property right. The difference between having a contractual right and a property right is between night and day. A contractual right enables you to have the right to buy, but you are not the owner. Once you sign the title deed, you are the legal owner. And after that, either the notarial office or the lawyers send the information immediately on the same day online to the land registry department. We talked about the land registry document, and your name will be registered as the new owner. In order to be able to sign the title deed, there are property taxes to be paid. And I will cover that immediately after this. Just a short mention to a document that sometimes causes some confusion in clients. Confusion between this and the promissory contract. This is what brokers and property agents, developers call a reservation agreement. So, a reservation agreement is not yet a promissory contract. It's what we can call a commercial document. And it's, in most cases, it's very handy when you need some time to get your due diligence in place. And there's a commitment, either from the agent or from the developer directly, that you have a number of days where you know that the property is off the market. And normally you pay a symbolic amount, which in most cases is refundable, just in order to ensure that the property is taken off the market. Sometimes that payment is by a check that it's not even cashed. Okay, we've covered that on the deposit payment. And what is very important in terms of the legal rules are the penalties. So, there are two different situations. When the breach of contract is by the seller, the amount of the deposit needs to be refunded in double. That's the rule in our civil code. Normally, this is very rare from my experience. And when it happens, they do that voluntarily. If not, you have to go to court in order to get your refund. Because one important thing to note is, unlike in the UK, the deposits in the vast majority of situations don't get in an escrow account, are not held in an escrow with the lawyers. They are paid directly to the seller. So there is, even though you are protected legally, there is an additional degree of risk. So ideally, if you have room to negotiate, the only way to reduce the risk is to negotiate a lower deposit. Going now for the property taxes, which you need to pay on completion. The main property tax in Portugal is called the IMT. And I have a table that on the next slide that will explain how it works. The IMT is the most expensive tax on property. It's a bit like the stamp duty in Portugal. The actual literal translation, stamp duty, is just a minor tax of 0.8%. Both of these taxes needs to be paid before the final deed. So you need to show that it was paid. These are taxes on acquisition, on purchase. Then there is the annual property taxes, similar to the council tax in the UK. The normal that everyone pays, the normal tax is the IMI. This is calculated on, we've talked about before, on the property tax value. And each municipality sets its rate for each year. So you may pay a little bit more or less if it's in Lisbon, in Faro, but it's quite low when compared to other jurisdictions. So it's between 0.3 and 0.5% only of the tax value of the property. And depending on the amount, this can be paid either in 3 installments, 2, or just 1. For holders of larger property estates, there is a more recent tax called the AIMI, which basically covers an additional tax on who holds more expensive property or properties. The tax authorities look at your total estate and then they apply the rate. So going for the IMT, this is the table for secondary habitation. So if you buy for your holidays or for investment, there is another table for permanent habitation, but the difference is not huge. In general, the average, we're talking about 1,000 euros less on the total bill. So how does this work? Up to 550,000, you need to see where is the bracket of the price. Let's see a 400,000 property. Where do you go? You go to the 8% rate. So you find the 8% amount, and then you deduct 11,035 euros. After you deduct that amount, that will be the amount payable of IMT. If it is above the 550 and up to 1 million, there's no deduction and there's a flat rate of 6%. Since a few years ago, there's a higher rate of 7.5% for properties above 1 million euros. For non-residential property and building land, rustic, there's a flat rate of 5% or 6.5% depending on the type of property. The IMI, as we discussed, urban between 0.3 and 0.5, depending on the municipality, and rustic, it's a flat of 0.8. AIMI begins, as I said, it's calculated on the sum of the tax values of all the properties owned. Begins at 600,000 at 0.7, then the maximum, when you have a total of tax values of your properties in excess of 2 million euros, you pay an additional 1.5% annually. When you own the property through a company, regardless of the tax value, you always pay additional IMI. So these are our contacts. As Christina said, we have a stand next door and we'll be able to assist with any further details. Thank you very much.